Yes, my lord. Maybe
Big not the mentioning
my lord,
mention on Monday.
extension of interim order, my lord. Interim order is going to expire on Monday, 15 December, my lord.
Let it be on 16th under the heading extension. Grateful, my lord. Sir, notice upon other side.
Item number 1.
I appear for the petitioner applicant for the lordship. This is my affidavit of service.
Where are the respondents?
But the last occasion they were present.
Appeared. Where is your affidavit of service?
Yes, I have.
What are the applications for?
Applications are one for condonation of delay of about 379 days, and the other is for restoration. I have narrated in pages, paragraph 8, 9, 10, 11. At pages 5 and 6.
What are the explanations?
Explanation that in spite of best effort, we could not get the matter.
Which paragraphs?
8, 9, 10, and 11. Pages 5 and 6. Yes. Can number 1, if your lordship kindly takes up. Can number 1.
You have to pay the cost of 5,000 rupees.
Or it would be
No.
too much. But a person who has retired,
No, twice matter was called on.
no. But I have explained that it was behind our back. It was not known to us. It was not known to us.
Nobody will believe it.
No.
Previously, twice matter was called on.
It was
Yes, sir.
not. It was not because of my instance. My lord, the matter was
Application being CAN 1 of 2025 is taken up for consideration by affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph.
But
yes.
if it can be reduced to some
No.
extent, but it will be a harsh upon the petitioner, your lordship.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Application being CAN 1 of 2025 is taken up for consideration, whereby applicant has prayed for condonation of delay in filing the recalling application, thereby praying for recall of the order dated 16 July 2024 passed by a coordinate bench on the connected writ petition. Next paragraph. On perusal of records and the explanation offered in the application, court finds on perusal of records and statements made in the application, court finds that the writ petition was taken up for consideration on 12 July 2024 and subsequently on 15 July 2024 when no one appeared for the petitioner. Stop. Thereafter, on 16 July 2024, when same situation prevailed, order was passed by the coordinate bench dismissing the writ petition for default. Next paragraph. Next paragraph. In the application, explanation which is offered is in the application it is stated that petitioner was not aware of the fact of inclusion of the matter in the list for consideration by the coordinate bench. Stop. Court is not fully satisfied with the explanation offered by the applicant in the application. Stop. Next paragraph. Order was passed by the coordinate bench on 16 July 2024 dismissing the writ petition, and application seeking recall of the said order dated 16 July 2024 was filed on 28 August 2025. Stop. Delay occurred in presenting recalling application is condoned subject to payment of cost of rupees 5,000 to be paid by the petitioner in favor of State Legal Services Authority. Stop. Cost shall be deposited with the State Legal Service Authority, Kolkata, by 7 days.
Another 1 week, or by beginning of
by 24th December 2025. Stop. Next paragraph. In default of depositing the cost in terms of the aforesaid direction, application seeking condonation of delay being can one of seeking condonation of delay in presenting restoration application shall stand dismissed without any reference to this court. Stop. In the event cost is deposited within the specified time, application being can 2 of 2025, seeking recall of the order dated 16 July 2024 shall appear before this court on 2nd January 2026 for consideration.
It will be.
If cost deposited, then it will appear in the supplementary list, your application seeking condonation of delay. If cost is not deposited, then your application seeking condonation of delay shall be deemed as dismissed.
I have understood everything, but I was.
And in case of depositing the amount, your recalling application will appear on 2nd of January 2026.
I have understood, but I was again praying before your lordship if that can be reduced, but it will be very harsh upon the petitioner before your
Not 2nd of January, on 9th of January. 2nd of January would be the that is not the combined list day. Very well, on 2nd of January.
But I'm again praying whether it can be reduced.
Sorry, I have given reasons.
Item number 2.
I'm for the
Lordship, I beg to appear on behalf of the applicant to Lordship. The applicant is filed contempt application for violation of the order dated 11 November 2021. As per his Lordship, Honorable Lordship, the applicant passed away on February 27, 2025. Thereafter, substitution application has been preferred by his legal aid.
Wait.
I apologize, sir.
This time I was saying it. Yes, amount payable, I am asking you, amount payable was communicated to the restaurant number 4 by the authority under the Payment of Gratuity Act. You are representing which contemner?
And retained in the certificate officer, Lordship.
Yes. What steps you have taken? Last occasion, submission was made that certain steps were taken in terms of
Yes,
the
yes.
judgment and order dated 7th
Lordship,
November 2025.
50,000 was deposited by way of the demand draft, and that has been communicated to the petitioner lastly. And private response got
Oh. What about the application on behalf of other legal heirs? Because you are the not the only legal heirs. There are 6 other legal heirs. So payment cannot be made in your favor. That's why matter was adjourned.
But in the meantime, Lordship,
Where is Mr. Ranonesh Go Thakurata?
Lordship, due to some personal difficulty, he couldn't appear before your Lordship.
Issue. Take steps for filing of substitution application by other. You take it back because I have not allowed substitution application. If
until
substitution application is allowed, I
Yes.
have recorded in the order dated 7 November 2025 that there are 7 heirs.
7 legal heirs.
7 heirs, and since out of which one heir has taken out this application,
Yes,
has
yes.
filed this application.
Yes.
So therefore, I granted leave to the line advocate of the represent applicant to take necessary steps for substitution of all the legal heirs. Now you may make a submission that the other legal heirs are not coming forward, but in that event, entire amount cannot be paid to the petitioner. Only proportionate amount, that is 1/7 of the amount, to be paid to the petitioner applicant. The choice is yours. Court cannot compel you to file an application on behalf of 6 other applicants or 6 other heirs. Now it depends upon their decision also. It is not the situation that it depends upon the decision of the learned advocate. Court is aware of this fact. But if it is not taken out by other legal heirs, then only 1/7 to be paid in favor of the petitioner, not beyond that. So considering this aspect, I passed an order on 7 November 2025 granting opportunity to other heirs to file applications seeking substitution, and leave was granted. If steps are not taken, then appropriate order is to be passed on this application.
Kindly please grant
And-
a further time, we would.
Yes. At the time of call, learned advocate representing applicant has prayed for accommodation which may enable him to take steps in terms of the order dated 7 November 2025. Next paragraph. You have for the alleged contemner is represented by learned advocate. Next paragraph. Hearing of this matter stands adjourned. Next paragraph. Paragraph lists the matter under the same heading for further consideration on 30th January 2025. আচ্ছা, ওই আগের অর্ডারটায় ওই শেষের দিকটা একটুখানি আমাকে বলো তো, একটা জিনিস চেঞ্জ, ওই যে ডিফল্ট ক্লজটা যেখানে বললাম একটু বলো তো।
Item number 3524, monthly list.
My lord, I am for the appellant, my lord.
But I beg to appear on behalf of the alleged contemner. Page 15 is
Just a
final.
minute. Affidavit of service.
Yes, my lord.
ঝামেলা করবে আবার ঝামেলা।
Yes.
But we have to reconsider, my lord, his case, my lord. May I only say this, my lord, may I come back?
No
sir?
steps, no exercise was carried out in
See
terms
the-
of the order dated 11th May
My lord,
2010.
I am to obtain instruction and assist your lordship on this, my lord. Recently, the brief is allotted to me. My lord, kindly grant me any time, some time, my lord, may I come back to your lordship, my lord.
We will let them take instruction. Old contempt application of 2010 issue. Affidavit of service filed on behalf of the applicant is taken on record. Next paragraph, uh, Mr. Nilotpal Chatterjee, learned advocate representing alleged contemner, has prayed for accommodation to obtain instruction in order to apprise this court whether steps were taken pursuant to the order dated 11th May 2010 passed by a coordinate bench or not. Stop. List the matter under the same heading for further consideration in the monthly combined list of January 2026.
I remain grateful, my lord.
Keep the bless, ma'am.
Item number 353.
Yes, affidavit of service.
Yes, my lord. My lord. On the matter, the lordship was pleased to direct the applicant to serve notice to the learned advocate of the alleged contemners. But my lord, the names of the advocates of the alleged contemners was not found in the member list, neither in the member list nor any vokalutnama, nor any vokalutnama filed in the record.
Alleged contemner Miss M.S. Jania Rudro and Songita Haldar.
Yes, ma'am. They are not, their name are not found.
Jania Rudro
Yes.
and Songita, but
So I have.
she appears before this court.
No, but my lord, no vokalutnama is there. Not their name was found in.
And
the
Songita Haldar, you serve upon them.
member
Court
list.
directed you need not consider the Vokalatnama. They appeared on 28 February 2025.
And address or the membership not found in the membership list. No.
Jania Rudro appears before this court and several courts. The learned advocates who appears on behalf of the state respondents, they know.
So I have served upon all the alleged.
That will not do. Old contempt, nobody will be represented. They will not be represented unless until you serve notice upon the learned advocate. Why you have not served?
My lord, I have not received any information about them.
What information is required? You take information from this court. It appears from the order dated 28 February 2025.
Name is there.
Serve upon them. You serve upon them.
But where they are sitting in the bar association or
That
the
court cannot tell you.
phone number
Yes,
is
sir.
there.
Affidavit of service filed on behalf of the petitioner is affidavit of service filed on behalf of the applicant is taken on record. Stop. However, service upon the learned advocate who represented the alleged contemner on 28 February 2025 is not effected. Stop. Learned advocate for the applicant is directed to serve notice upon Miss Jinia Rudro, learned advocate who represented the alleged contemner on 28 February 2025, enclosing copy of this order by December 2025. List the matter under the same heading in the monthly combined list of January 2026.
My lord, another thing is the
Next
appearance
matter.
of the state.
You
is
serve and
required.
come back.
My lord, the state is required. The
Please serve and come back.
My lord, I have tried to serve the copy upon the state respondent.
Please serve and come back. Next matter, please.
Item number 354.
The state did not appear, and I have tried to serve, but he has not accepted the notice.
Same thing.
Yes, my lord. The learned advocate appeared, Mr.
No, here Mr. Mrinal Kanti Ghosh and Kartik Chandra Kapas. You do not know them. You are representing. Yes.
No.
Yes.
I am for the petition. Item number 354.
Item number
354.
354. Yes. Yes. Your matter is over. Yes.
I am also be directed to serve notice to the GP, madam.
No.
The state will not.
No.
My lord,
Yes.
order passed by the Honorable Retired Justice Devasis Korgupta on
For the applicant, praise for an exception to exception. Yes, what you are submitting?
my lord, order passed by the Honorable Retired Justice Devasis
Yes,
Korgupta. Order passed by the Honorable Justice Retired Justice Devasis Korgupta on 13th September 2010, my lord. ঠিক আছে?
But today no one is representing the alleged contemner. For the first time before this court, you serve notice upon the learned advocates Mrinal Kanti Ghosh and come back. Issue. At the time of call, no one is representing. Alleged contemners. No one is representing alleged contemners. Stop. Next paragraph. Learned advocate representing the applicant is directed to serve notice upon Mr. Mrinal Kanti Ghosh, learned advocate who represented alleged contemners on 3rd September 2025 by enclosing copy of this order by 19th December 2025. Stop. list the matter under the same heading for further consideration in the monthly combined list of January 2026.
For the Mrinalkanti Ghosh, appear earlier, but after that, the contemner was appointed by one corpus. One corpus, large advocate. The
Yes,
alleged contemner appeared by filing a report. That report I also challenged, but that report was made not for the respondent 2, but respondent 3.
no, but Mrinalkanti Ghosh is not appearing for the contemner now.
No,
But his name is there.
his name is there when the contempt proceedings was initiated.
Yes, but subsequently nobody appeared for the contemner. They দাও তো ফাইলটা।
One corpus, Karthik
Karthik.
corpus, Karthik.
No, you are making mistake. Last occasion matter was taken up on 3rd September 2025. 3rd September. 2 months back, 3 months back, when Mrinalkanti Ghosh and Karthik Chandra Kapas appeared.
Yes,
You
sir.
serve upon Mr. Mrinalkanti Ghosh.
All right.
Item number 355.
Page 21 is the impugned order, my lord.
You are appearing for the applicant.
My lord, for the alleged contemner.
Contemner. Who is appearing for the applicant?
My lord, I find from the order, my lord, page 21, my lord, we find Mr. Amit Kumar Pan was appearing for the petitioner. And my lord,
Last it was taken up on 6th August 2025.
Right.
So in absence of representation on behalf of the applicant, it would not be proper.
my lord,
Let me give another chance to the
certainly,
applicant.
certainly, my lord,
And you serve a notice upon the learned advocate representing the applicant.
as my lord pleases, my lord.
Since in other matters, when
Certainly.
contemners are not represented, court
Certainly.
directs the applicant to
Certainly,
appear,
my lord. Certainly,
applicant to serve notice.
certainly, my lord, I
So
bow.
it is here the situation is reverse.
It's always justice for my lords.
You are representing land acquisition collector.
My lord, my lord.
At the time of issue, at the time of call, no one appears for the applicant and no accommodation is paid for.
Advocate on record.
Next paragraph. In order to give one more chance to the applicant, hearing of this matter stands adjourned. Next paragraph. However, alleged contemner is represented by learned advocate. Next paragraph. Learned advocate representing the contemner is directed to serve notice upon the learned advocate who represented the applicant on last occasion. Enclosing copy of this order.
There is an advocate on record mentioned in the
Enclosing
contempt
copy of this order by 19th December 2025.
My lord.
Next paragraph. List the matter under the same heading for further consideration in the monthly combined list of January 2026.
I remain grateful, my lord.
Item number 356.
Mr. Hajra, Subir Hajra, Mr. Salauddin is appearing. He sits in your room. Inform him that this matter is today. I am adjourning the matter. It will appear in the monthly combined list of January 2026. Inform. At the time of call, no one appears for the applicants and no accommodation is paid for. Applicants করবে substitution হয়েছে and no accommodation is paid for. Stop. List the matter under the same in order to give one more chance to the applicants hearing of this matter stands adjourned. Next paragraph. List the matter under the same heading for further consideration in the monthly combined list of January 2026. Informing. Item number 356.
Item number 357.
I appear for the applicant. Lordship had granted me leave to file an exception to the affidavit of compliance. May I file it in court, my lord?
কমপ্লায়েন্স কোথায়? আমি তো দেবো কমপ্লায়েন্স।
My lord,
There was a direction for my lord filing affidavit in compliance. My lord, I have filed. My lord, my learned friend, my lord, maybe file a
What
exception.
exception? Let
My
me
lord,
see that
except
what
My lord,
steps
the
you have taken.
order has been complied with. My lord,
Let me
my lord,
speak.
I state that order is not complied with. Lord.
Yes.
Lordship, the order was passed in 2008, my lord.
Just a-
Yes.
You are representing director of local bodies. Now, where is your affidavit of compliance?
my lord, I have filed my lord the affidavit compliance on my lord.
Today you have filed.
No. It was filed.
My exception
My lord,
today.
Today you have filed your exception.
Exception,
Yes.
my lord.
Region order passed. Page 10.
Page 12.
Page 10. The region order passed by director of local bodies. My lord,
Page 10 is the order, not review order.
no, my lord, 10
Director of
from
local
10
bodies passed an order.
Yes, my lord, 10 from my my lord, compliance report. Repetition of the repetition.
Yes, where is the contempt?
My lord, may I just humbly submit, lordship. 2013, they say that my name is
Yes.
in 2013. They say that and that was not communicated to me, my lord. In 2013, they say that my name is appearing in the 11th position, and it is their own contention at page 11, my lord, that thereafter in 2015, 2018, 2019, they have given appointments to others. Then where was the predicament or
But
difficulty?
court has the difficulty in deciding the issue in contempt. If you are agreed by the order passed by the director of local bodies, then you can challenge it in accordance with law. But in the writ petition, what was the direction
Yes,
passed by the coordinate bench in 2008? Come to the relevant part of the order where
yes,
the
my lord.
direction content
Yes, my
that
lord.
the director of local bodies West Bengal is further directed to communicate his decision regarding such approval to the municipal authority.
My lord.
So decision was taken, rightly or wrongly decision was taken. It was communicated to the municipal authority or Krishnagar municipality. Now, if you are agreed by this decision,
My lord.
remedy does not lie in proceeding with the contempt.
My lord, I was not considered for any other post. Here they
Consider, read J.S. Parihar's case.
My lord, only one
Supreme Court.
humble sum.
Here, the validity and legality of this, you may have been agreed
My lord,
by the decision taken by the director.
my lord,
Even court proceeds on the premise that decision is wrong.
my lord.
Now, the remedy does not lie by pursuing a contempt petition.
My lord, I bow down to my lord. Only one humble submission, if I am allowed to make. There was no specific direction in the solemn order that only for the post of Mazdoor I have to be considered. There were other posts.
Yes.
Humbly submit, my lord. The others were appointed for
Court
the
directed
post of...
commensurating with the
Yes, my
educational qualification of the candidates.
Yes, my lord. And my educational qualification, because municipality itself had taken much prior a decision in 2007 that I can be appointed in the post of peon, cashier peon. And in this particular order, they have only considered
So
the
your
post of
contention is
Mazdoor.
that the empanelment of the petitioner as at serial number 27 does not give right to the petitioner to be considered for appointment against Mazdoor only.
Only Mazdoor.
But other posts are there
Other
where
posts,
petitioner could have been considered.
yes, my lord.
But rightly or wrongly, the director has taken a decision. In the contempt, the validity of this decision cannot be gone into.
My lord, humbly submit if they can at least consider me for other post in...
If it is not considered, then you have to take steps in accordance with law. But in contempt, remedy does not lie in contempt. After the exercise is carried out by the chairman of the by the director of local bodies.
Then my lord will
Yes.
kindly grant me leave.
Matter is heard in presence of the matter is heard in presence of the learned advocates representing the applicant and alleged contender.
My lord, may I just interject once, lordship? May I place one order of this honorable court of 2013, where lordship they had...
Alleged contemners.
My lord, they had taken the... My lord will kindly peruse it once. They had taken the same point, my lord. At that point of time, my lord Justice Jyotirmay Bhattacharya, as his lordship then was, had taken up this matter, and he had issued a rule, which lordship had issued a rule which is discharged. Kindly sees, my lord, at the bottom of first page, Mr. Mukherjee further submits a decision which was taken by the director of local bodies in pursuance of the directions passed were also communicated to the municipality. Copy of the letter showing consideration of the panel sent by the municipality to the director of local bodies by him has been placed. It is submitted by Mr. Mukherjee that turn for giving appointment to the petitioner on compassionate ground has not yet matured, and his position in the panel as on March 2013 is 11, and 6 candidates who were all above him in panel were appointed on the compassionate ground. Under such circumstances, for ascertaining whether the order of this court was complied with by the alleged contemner in its true spirit or not. I direct the alleged contemner 1A to file affidavit in this contempt proceeding within 3 weeks. His lordship was also had opined, my lord.
Yes.
My lord, his lordship was had the observation fell from his lordship that whether it was carried out in true spirit or not.
Yes, there's a direction for affidavit. Now the affidavit of compliance is filed. From the affidavit of compliance, it appears that the decision is taken by the director of local bodies. But the validity and legality of this direction cannot be delved into in a contempt petition.
As my lord directs.
Issue. Contempt application is heard in presence of the learned advocates representing the applicant and alleged contemners. You are representing Krishnanagar municipality or director of local?
No, only for director of local body.
Representing applicants and alleged contender number 1. Stop. Today, on behalf of the applicant, an exception to the affidavit of compliance is filed and same is taken on record. Next paragraph. Learned advocate representing the applicant submits that order passed by the coordinate bench on the connected writ petition on 15 December 2008 was not complied with in its true letter and spirit. Stop. Prayer is made for giving appropriate direction to ensure compliance of the order dated 15 December 2008. Next paragraph. On the contrary, learned advocate representing alleged contender number 1 has submitted based on decision taken by the said alleged contender number 1 dated 5th May 2025 that the order dated 15 December 2008 is complied with. Stop. On perusal of affidavit of compliance affirmed on 8 May 2005, on behalf of alleged contender number 1, it appears that alleged contender number 1 passed an order on 5th May 2025. However, from the submission made on behalf of the applicant, it is perceived that applicant is not satisfied with the order passed by the alleged contender number 1 on 5th May 2025. Next paragraph. It is tried that if after steps taken by alleged contender and decision taken in terms of the order of court, applicant is not satisfied, option which is left open to the applicant is to take steps against such decision in accordance with law. as rightly or wrongly alleged contemner has taken steps. Stop. Hence, contempt application stands disposed of and contempt proceeding stands dropped. However, this order shall not preclude the applicant to take steps in accordance with law against the order dated 5th May 2025.
I'm deeply obliged, my lord.
Application আছে connected.
My lord,
Why
can
can
was disposed of, my lord.
can was disposed of?
Disposed of, lordship.
আমারও
Just
saying no,
to,
can was disposed of. Just a minute. Yes, rightly said. Can disposed
It
of
was
on
disposed of.
17 December 2024.
Yes, my lord. Deeply obliged, my lord.
Item number 358.
Okay, Mr. Siddiqui is online. You
Lord, I appear for the alleged contemners, my lord.
Yes.
Due to personal difficulty, my lord, I could not come to the court today physically, my lord. I tender my apology.
Yes. Whether the order is complied with.
Right, order, there is no violation of the order as such. Lord, this is mockery of the contempt proceeding, my lord. In fact, this contempt proceeding is liable to be dismissed with exemplary cost.
Sure. Must have kindly come page 19th of the contempt act. Lordship, the writ petition, Lordship,
Just a minute. Just a minute.
the
Please wait.
জিজ্ঞেস করো চারজনটা কোথায়
It is a sort of interim order due to pendency of the appeal before the Supreme Court. So what was the fate of that appeal before the Supreme Court?
still paying.
Still pending.
Now, Lordship, kindly come.
What was the order passed by the Supreme Court? Court directed to ensure that the order passed by the
Kindly
Supreme
come to
Court.
the writ petition.
What was the order passed by the Supreme Court?
No third party interest shall be created.
Show me that order.
Yes. Kindly come to the copy of the writ petition.
Yes.
Kindly come to the copy of the writ petition. That is page 59. Sorry, page 25. Sorry, page 25 of the writ petition.
Page 27 is the relevant part.
Now I will come to the 27(8) later on. Let's kindly initial interim order.
The 24th November 2003 order is
Just
the
a
order
minute,
which was
just a minute, just a
page
minute.
27.
We put down in the matter of
Yes. So this is the order.
yes. On Lordship, the penultimate paragraph is, we are of the view the authorities of the state shall ensure, notwithstanding the vesting order that may be passed and mutation that may be effected in the revenue record, but no third party rights shall be created and no such third parties be inducted or allowed to ensure upon the and squat on such properties pending disposal of this appeal.
So any third party right is created.
Yes. Now, Lordship,
How it is created?
they have forcefully occupied the agricultural land and they are cultivating.
Who are cultivating?
The third parties who are the
No, at the instance of the state, whether there is any creation of third party, right?
But
At the
after
instance of
this
the
order,
state respondent.
after this order, some third parties, they have forcefully started to cultivate this land. Now, Lordship, they preferred an appeal. Lordship, kindly come to my supplementary affidavit. I have affirmed it on 24th July 2019. This order was under challenge before the Honorable Division Bench.
Which order?
This order passed by the Honorable Coordinate Bench, which is the subject matter of contempt in this before this court.
That challenge failed.
That challenge failed. Now, subsequently, kindly come to the supplementary affidavit that is affirmed on 24th July 2019. Now, review also failed. Now, they have challenged.
Supplementary affidavit.
Supplementary affidavit affirmed on 24th July 2019, affirmed by the petitioner. So kindly come page 7.
No, supplementary affidavit is not available on record.
Another records is also.
দাও তো দেখো তোর মধ্যে সাপ্লিমেন্টারি এফিডেভিট
Legal side job. Legal side. Kindly come page 17. This is the dismissal order of
24 July 2019.
Yes. First order is the delay condition.
Yes, supplementary.
18 July 2017. Page 16. That's so kindly come page 16.
Yes.
That is the order of the Honorable Division Bench. Now, Lordship, kindly skip page 17. Who is the one of the person? Because before the Honorable Division Bench, the appellants, Lordship, the contended that they are cultivating this land, which is not been vested. And Lordship, we are the protected by the Honorable Supreme Court.
Is the order of the Supreme Court that you have placed before?
That is in the writ petition, page 28.
Writ petition. আছে আছে বুঝতে হবে নাকি আছে এখানেই আছে Yes, you are placing order of the division bench dated 18 July 2017 from the supplementary affidavit.
Yes. 18 July 20. Kindly come page 17, the next page. This is an application, Lordship, seeking leave to appeal taken by one of Dilip Mehna in respect of an order dated such and such, such and such. Now, admittedly, the appeal is a third party seeking to assert this right of consequent upon the order passed by the divisional and subdivisional magistrate Rampura Birbhum in terms of the memo dated 31st March 2017. The subject matter of controversy surrounding the instant matter was carried right up to the Honorable Supreme Court by Paschim Bango Rajya Bhumijibi Sangho and another in SLP Civil 1416 of 19.
Just a minute. Yes.
Now, also kindly come page 22 of the supplementary affidavit. Now, the Honorable Supreme Court, in terms of the order dated, that is 5th February 2018, again, Lordship, the quoting the order of the 2003, Lordship, please to observe that having heard learned counsel, we direct the respondent to give effect of the order in letter and spirit.
This is subsequent order of the Honorable Supreme Court in the same SLP.
Same SLP. Now, Lordship, kindly come page 24.
Now, your contention is that third party right is created.
third party right has been created. Lordship, they went, not only that, Lordship, kindly come the subsequent pages. It appears thus the
Yes,
response.
yes, Mr. Siddiq,
My lord, I'm audible, my lord.
it is alleged on behalf of the applicant that the third right is created.
My lord.
Third party
No, my
right,
lord.
how you can create third party right?
No such third party right has been created. Let me make certain things clear, my lord. First of all, my lord, the honorable single judge, while disposing of the writ petition, directed the state respondents to comply with the order passed by the honorable Supreme Court in the case of Paschim Bongo Bhumijibi, the order dated 24th November 2003. The order which has been shown to your lordship.
No, order is very clear, 20th June
Clear.
2012.
24th November 2003 order is very clear, my lord. I'm grateful to your lordship.
No third
On a
party right
careful
to be
that
created
shall be
and
created.
steward on the property of the petitioner.
Yes. Now, your lordship may kindly ask the learned counsel for the applicants to show on after that particular date any third party right has been created at the behest
He
of the
is
state.
saying that the other is cultivating the land of the
No,
petitioner.
there is no instance at all. In fact, I'll tell you, Lordship, what has happened. In fact, those third parties which were created prior to 2003, he is trying to bring it here by way of this contempt application. He's juxtaposing the matter. What has happened, I tell you, Lordship. Prior to 2003, those who have entered into the land squat over the premises, my lord, he could not get any order from the honorable single judge that
So
kindly direct the state.
your contention is this the first order was passed by the Honorable Supreme Court on 24th of November 2003.
2003.
Subsequent thereto, there was no creation of third party right.
There was no creation of third. He will not be able to show a single piece of paper that any patta has been issued on and after 24th. I mean, I'm not taking 2012 order passed by my Lord Justice Shaumitropal, his lordship then was. I will take 2003. I'll
Yes,
take the instance of
24th November
2003.
2003 is the date to be reckoned.
Right. I'll take that order. My lord, though my lord Justice Shaumitropal has not said that you have to comply with the order of 24th
Now,
November
according to
2003,
you,
but
Mr. Mukherjee,
huh.
who in whose favor this right is created?
My
Third
lord,
party.
no one's favor. I'll tell you, Lordship. Now,
Yes,
your
just a
Lordship
minute.
kindly take.
I will hear you if
My
necessary.
lord, I'll just.
According to the applicant, in whose
Lordship,
favor it is created.
No, my lord, I did not say a single word. That is the problem
Yes.
with Mr. Mukherjee. He never allows anyone to make submission. Now, my lord, if your Lordship kindly sees again the Honorable Supreme Court's order. My lord, I'm troubling your Lordship with that Honorable Supreme Court's order. 24th November 2003 order.
Yes.
My lord, may kindly bear with me. Hmm. My lord, if your Lordship kindly sees the operative paragraph on a careful consideration, has your Lordship got that?
Yes, yes.
Of the respective submissions of the learned counsel appearing on either side, both sides. We are of the view that the authorities of the state shall ensure, notwithstanding the vesting orders that may be passed and mutation that may be effected in the revenue records, the state shall ensure that notwithstanding any vesting order that may be passed, they can pass the vesting orders, mutation that may be effected in the revenue records, comma, no third party rights should be created and no such third parties be inducted or allowed to enter upon and squat on the properties pending disposal of the appeals.
Yes.
Now, what this order is binding to both the parties on either side, appearing on either side. Or what has happened, your lordship, my lord, this petitioner, in fact, in violation of the Honorable Supreme Court's order and in violation of Honorable Justice Shaumitropal's order, has sold off the land and created third party right. Now, when I made this submission before this honorable court, your lordship may kindly seize the order in the contempt application on 17th December 2024 in this contempt application. 17th December 2024, the order passed by my Lord Justice Bharadwaj.
Just a minute. Just a minute.
Yes, yes.
Yes, 17 December
December.
2024.
Well, I submitted, learned counsel appearing for the respondent authority have submitted that in violation of the court's order, the applicants has sold out a portion of the land in question. Learned counsel appearing for the applicants praised leave to file a supplementary affidavit stating categorically, a statement made from the bar, that no plots of land was sold out to the applicants, which is under consideration before the court. Lordship may kindly mark that. Now, my lord, I file an report in the form of an affidavit on behalf of the alleged contender number 1. Your Lordship may kindly take a report in the form of an affidavit filed by the alleged contender number 1.
Just
This is of February 2021.
এই দেখো তো রিপোর্ট আছে কিনা ওখানে
Alleged contender number 1, the district magistrate Bhurbhum.
রিপোর্ট in the
Report
form.
in the report on affidavit filed by the alleged contender number 1.
Just a minute.
My lord, my lord.
ডিএম এর একটাই আছে কাছে কাছে ডিএম এর আছে
Your Lordship, your Lordship may come. It Lordship may come.
Was affirmed when?
On February 2021, my lord.
9th February 2021.
2021. Your Lordship may come directly to page 91. In 2018, a deed of conveyance was executed.
91.
91. Has the Lordship got that? In 91, this deed of conveyance was executed. The Bikreta, if your Lordship kindly sees in page 92, Bodhanath Mondal. He is the Bikreta. He is the vendor.
What is the date?
Well, the date is
12 December
first page.
20, yes.
The
First
date is
page.
the date in the Bengali deed
11
of conveyance.
December 2018.
11 December 2018 at page 95. At page 95. Now, what was submitted in 17 December 2024? Learned counsel appearing for the applicants. I take your Lordship again back to that order of 17 December 2024. Learned counsel appearing for the applicants praised leave to file a supplementary affidavit stating categorically that no plots of land were sold. Now, my lord, he has filed a supplementary affidavit. Supplementary affidavit on behalf of the petitioners. Pursuant to the leave granted in 2024, he has filed a supplementary affidavit dated 6 January 2025. Has the Lordship got that?
Just a minute. Supplementary affidavit dated 6 January 2025.
Right. Supplementary affidavit on behalf of the petitioners. On behalf of the petitioners.
Yes.
My lord, supplementary affidavit, I'll take you to the, my lord, to the relevant portion, my lord. Your Lordship may kindly turns to page 4.
Page 4.
Of that paragraph 6. Has the Lordship got that paragraph 6?
Yes.
Now, my lord, if your Lordship kindly sees the last 3 lines. At present, he is 80 years old, that is petitioner. Due to scarcity of fund and medical issues, the applicant number 2 has been compelled to transfer 8 decimals of land in favor of one unauthorized occupiers in a very little price. If the petitioner applicant number 2 did not transfer the same, the petitioner had to meet with an acute economic condition. Now he's making stories. Acute economic condition, having no other alternative remedy. The petitioner number 2 transferred 8 decimals of land in favor of unauthorized occupiers through registered deed. Now, my lord, this petitioner will be coming to the court also. I've seen him coming to the court in a very shabby. I don't want to say that. Just to portray that he has not done anything wrong. He was in a very bad economical conditions. He had to sold off the land. Now, my lord, first of all, this submission was made in 17th December 2024. I have not sold off the land. I'll file a supplementary affidavit. Now, he had to make a statement on oath. He says, yes, I've sold off the land, but due to economic crisis, I've sold off the land. My lord, he is violating the Honorable Supreme Court's order. And I'm challenging my learned friend to show that on and from 2003, I have issued patta to anyone. I have created any third party right.
Now, there is an allegation by the applicant that others are cultivating land of the petitioner. How
But
that
he
is
has,
permissible?
he has no, my lord, that is what I am on. He has what he is saying prior to 2003. Whoever has entered into the land, the Honorable Supreme Court has directed that status quo should be maintained. On and from 2003, no third party right should be. No, my lord, he is trying to put the clock back. He's trying to put the clock back. My lord, I am not taking the date of Honorable Justice Soumitra Pal or 2012.
No, he is not
because, my
trying.
lord,
He is trying to put the clock front. What was the position in prior to 2003? Now he is trying to project that this right or this exercise was carried out by third party illegally
after
the order was
2003.
passed.
After 2003, they have entered
That
into
is your
that.
contention.
What he's saying, he's trying to show that these people have entered into these premises or these particular pieces of land after 2003. My lord, though the cardinal date in this particular case, my lord,
I will
In
come
spite
later on.
of the order, no. In spite of the order passed by the Honorable Supreme Court,
That
not
is
to
in
create third party.
2018. Lordship, I am a owner of a huge property. Even
Maybe,
there is a,
but what was the order passed by the Supreme Court?
Supreme Court's order is
The order of the Supreme Court. Order of the Supreme. Please don't raise your voice. The order of the Supreme Court gets diluted by your conduct.
Lordship, so far my contention is this Honorable Supreme Court's order.
What was the order passed by the Honorable Supreme Court on 24th November 2003?
Yes.
On a careful consideration of the respective submissions of the learned counsels appearing on either side, we are of the view that the authority of the state shall ensure, notwithstanding vesting orders that may be passed and mutation that may be affected in the revenue records, no third party right should be created, and no such third parties be inducted or allowed to enter upon and squat on such properties pending disposal of the disposal of the appeals. You yourself has violated the
Let me clarify.
by selling the land.
Lordship, let me clarify. The Honorable Supreme Court's order in respect of the land which is supposed to be vested. Now, Lordship, this land I cannot transfer. But Lordship, petitioner is the owner of a huge property. Now, Lordship, entire property.
You yourself has admitted in by filing an affidavit that at present his AGS custody fund and medical issues, the applicant number 2 has been compelled to transfer 8 decimals of land. Yes, the applicant is not authorized to transfer even 1 decimal of land by virtue of the order of the Supreme Court. For that, you should have moved an IA before the Honorable Supreme Court seeking leave.
Now, Lordship, my contention is
land in favor of one of the unauthorized occupiers in a very little price or in lieu of little price. How you can do this?
8 decimal of land, Lordship, the petitioner for his survival has had to sold. Now, Lordship, they kindly consider this order of the Honorable Supreme Court restricted only in respect of the land which is supposed to be vested. The vesting, definition of vesting is unknown.
No, that is not the purport of this order. Sorry, it is stated specifically, it is directed that no third party right should be created and on such third parties no such third parties be inducted or allowed to enter upon and squat on such properties pending disposal of the appeals. That is not restricted to the land which you are submitting.
Lordship, this sale is 2018. Lordship, kindly come to page 24 of my supplementary. I could not place my case. Whatever their contention, they are ready and willing to comply the order of the Honorable High Court. They went to the spot. Some of the plots has been handed over to me. Possession has been handed over from the encroachers of the third parties. But in
one hand, you are saying that the government in violation of the order passed by the Honorable Supreme Court, inducted third party, created third party right. On the other hand, it appears that you yourself have sold out a portion of the land, and that you have stated by way of
Lordship, if it is a
so therefore
Lordship, if it
therefore it does not instill confidence in the mind of the court with regard to the conduct of the application.
Lordship, if it is a sold, Lordship, the
Not if it is. You have by affidavit you have said.
Lordship, I have sold. If I sold the Lordship, what is the order of the Honorable Supreme Court that no third party interest will be created? If I transfer the vested land, that will be created difficulties. Lordship, law its take own course, that the sale will be cancelled. Lordship, there is a provisions of law that if I transfer the vested land, the law of its own course, it will automatically cancel the Lordship.
But what about your conduct? That is in the teeth of the order of the Honorable Supreme Court.
Lordship, that is in 2008.
These are other things you are submitting about the consequences of land which is a vested land if it is sold. But what about your conduct?
Lordship,
can you do this? In one hand, you are saying that there is a creation of third party by the state authorities. On the other hand, you are saying that you have sold a
state
portion of the land.
Take the advantage of this thing because state, when unable to comply the order of the Honorable High Court, when the state went to the spot and due to obstruction,
Mr. Siddiq, by filing an affidavit, you disclose that after the order passed by the Honorable Supreme Court on 5th, on just a minute, in 2000, just
28th February 2003, my lord.
Yes, on
24th November
2003, that you have not created any third party interest.
But I will. I'll file an affidavit. But you that is the only sole contention of the order of the Honorable Supreme Court.
Because what was the position? Because still the appeal is pending before the Honorable Supreme Court.
If your lordship may kindly recall what my
prior to 24th of November 2003, what was the position? Court is not examining or not scrutinizing. But as you have submitted that from 24th of November 2003, there ought not to be any creation of third party right at the instance of authorities or alleged contemnants. To that extent, you file an affidavit, disclose and demonstrate that there is no creation of third party right in favor of a third party right in connection with the land in question after the order passed by the Honorable Supreme Court on 24th of November 2000.
I'm grateful, your lordship. I'll file that.
Lordship, kindly come page 41. It appears.
Contempt application is heard in presence of the learned advocates representing the applicant. Representing the applicants and alleged contemnants. It is contended on behalf of the applicants that in violation of the order passed by the Honorable Supreme Court on 24th November 2003, in special leave to appeal within brackets civil close bracket number 1416 class 1997 within bracket Poschimbango Rajyo Bhumijibi Sangho and another এইভাবেই লিখে দেবে সুবিধা হবে বুঝলে and another versus state of West Bengal read with order dated 20 June 2012 passed by a coordinate bench on the writ petition being WPA 12204 of 2012. Third party right is created, thereby third parties were inducted and allowed to enter and squat on such properties, squat on the properties in question. Stop. It is also submitted on behalf of the applicants that creation of creation of right in favor of third party also permitted them to cultivate the land in question. Stop. During course of hearing, reliance is also placed on the order of the Honorable Supreme Court dated 5th February 2018, passed in passed in SLP within bracket C close bracket 1416/1997. And the order passed by the Honorable Division Bench. Where is the order? By Honorable Justice Somadar.
Yes, that is the Lordship, the supplementary affidavit, page 13. Relevant.
Honorable Division Bench.
Page 16, Lordship.
Dated 18 July 2017. Passed on an intra-court appeal being MAT 773 of 2017 within bracket Dilip Mehena versus the state of West Bengal and others. Next paragraph. On the contrary, Mr. Tale Masood Siddiqui, learned senior advocate, representing alleged contaminants, submits that there was no creation of third-party right in violation of the order of the Honorable Supreme Court dated 24th November 2003 and the order dated 17 November 2024, passed by a coordinate bench on the connected writ petition.
It won't be, my lord, 17 November 2024. It will be the order passing the writ petition, 2012 order.
17 December 2024 as well as the 17 December 2024 rests on the order passed by the Honorable Supreme Court dated 24th November 2003.
No, that is 28 June 2012. No, 2024 is the order passing this contempt application.
Just
28 June 2012.
Yes, just.
Subject to correction.
Yes, you are correct. It is not 17 December 2024. Yes.
It is 28 June 2012.
Yes. Bolo. And dated 24th November 2003. Just contempt petition. And the order dated 28 June 2012 passed by the coordinate bench in the connected writ petition. It is 28 June 2012.
12, right. I'm grateful.
Stop. It is also submitted. Position might have been different before order was passed by the Honorable Supreme Court on 24th November 2003. But after the said order was passed, by any omission or commission on the part of the alleged contemners, no third-party right was created in connection with the properties in question. Next paragraph. It is also submitted on placing reliance of the report of on placing reliance of on placing reliance on the report of the alleged container number 1, which was affirmed on 19th February 2021, that the applicant, which applicant has transferred the part of land by way of sale?
Applicant number 1.
Boidunath Mundul.
Yes.
That applicant number 1 sold out part of the land in question by executing deed of conveyance on 11 December 2018, and said conveyance deed is annexed to the report of the alleged container number 1. Stop. Attention of this notice of this court is also drawn to the statements made on behalf of the alleged contemners in the supplementary affidavit in paragraph 6, wherefrom it appears that it is admitted, wherefrom it appears that there was admission on the part of alleged contemners, on the part of the applicants, relating to sale of land, sale of part of land in favor of third party.
Lordship, may kindly mention the date of the supplementary affidavit.
Stop. Next paragraph. Sum and substance of the submission made on behalf of the applicants, on behalf of the alleged contemners, is it is not the state authorities, rather applicants created third-party right in connection with the property in question, in violation of the order passed by the Honorable Supreme Court on 24th November 2003, and the order passed by the coordinate bench on 28 June 2012 on the connected writ petition. Next paragraph. District Magistrate Birbhum, present District Magistrate Birbhum being the alleged contemner number 3, is directed to file an affidavit by 1 week after ensuing, by 1 week after, or by 24th December 2025.
24th December, my lord. Kindly give my lord 1 week after the vacation.
Very well. By 1 week after ensuing
Right.
Christmas vacation,
Christmas.
1 week after ensuing Christmas vacation, disclosing whether steps have been taken in terms of the order dated 24th November 2003 passed by the Honorable Supreme Court and the order dated 28th June 2012 passed by a coordinate bench to ensure that there is no creation of third party right in connection with the properties in question. Stop. Next paragraph lists the matter under the stop. Let a copy next paragraph copy of the affidavit to be filed by the alleged contempt copy of the affidavit to be filed by the
By the
alleged
present, Malad, your lordship may kindly mention my present district magistrate. Malad, because there has been reshuffle, I am not aware whether the said district magistrate is there or not. Present district.
present magistrate Birbhum করে দেবে copy of the affidavit to be filed by the present district magistrate Birbhum shall also be served upon the learned advocate representing the applicants by 7 days thereafter. Next paragraph. List the matter under the same heading for further consideration in the monthly combined list of February 2026.
Lordship, in respect of applicant number 1, which is the transfer, it will be applicant number 2. Lordship, I'm sorry that my learned
just
only this portion, applicant number 2.
Ajay Kumar Mondal is the applicant number 1. Bodhanath Mondal is applicant number 2.
That sale conveyance relating to conveyance did what I have dictated.
That is yes. That will
Yes.
be.
That is yes.
That will be applicant number 2.
Seller is Boidonath Mondal.
Yes, yes. So he will be the applicant number 2.
Boidonath Mondal is applicant number
2.
Number 2.
এটা এইভাবে সুবিধা ওইভাবে ঘুরিয়ে দেবে না নাহলে আমার এগুলোকে দেখে দেখে তো কারেকশনটা করতে হবে সব এইভাবে থাকবে তোমারও সুবিধা হবে দেখে না
I'm grateful, my lord. Grateful.
Yes, call the list.
Item number 359.
রিট পিটিশনটা কোথায়? রিট পিটিশনটা অনলি কন্টেম্pt।
এইটা তুলে দেবো। AC number, right?
At the time of call, no one appears for the applicant and no accommodation is paid for. Stop. In order to grant one more chance to the applicant, hearing of this contempt application stands adjourned. List the matter under the same heading for further consideration in the monthly combined list of January 2026.
Item number 360.
In this matter, I am paying for only accommodation on behalf of Mr. Pola Chandra Ghosh. Yesterday evening, he held deal at his house, my lord. That's why he has not come to court.
My lord, compliance report in form of an affidavit have been prepared, my lord. Only, may I just point out, your lordship, the last occasion when my lord directed to file this report in form of an affidavit, in the meantime, on 20th of November, my lord, the DI has been released and, my lord, the name of the then alleged contemner, my lord, maybe.
Amend the cost rate.
And a copy may be served, my lord. This is the order, my lord, of
The DI is changed.
my lord. It's changed, my
So
lord.
who has affirmed the affidavit?
My lord,
Present DI or the erstwhile?
the erstwhile, my lord, since the direction was there, an
Sign
amendment.
affidavit of compliance.
My lord, a fresh compliance, my lord.
No. What you have prepared, file it. Because that TI is also party.
My lord.
Have you complied with the direction?
No, my lord, it cannot be, my lord. The reasons are there, my lord.
It cannot be means?
My lord, the compliance, my lord.
Whether you have complied with the order.
No, my lord, it has not been complied, my lord.
Why it has not been
My
complied?
lord, on recalling application is pending, my lord, in
That's
connection with that.
will not
No,
comply.
my lord, that is not. The DI has no power. The direction was given upon the DI, my lord, to give effect since 1997. At that point of time, my lord, it was not been pointed out that there was no sanction vacant post, my lord, against which, my lord, this appointment has been, my lord, held to be regularized.
File your affidavit of compliance.
My lord, this is my lord. My lord, we have already served a copy upon the petitioner. My lord, we have already served upon the petitioner. This is the declaration.
The appointment is prior to coming before the function.
Now, Panibrata Das is not the present DI.
No, my lord.
He has been changed.
My lord.
Now the affidavit of compliance has been affirmed by Panibrata Das.
My lord.
File it. Affidavit of compliance filed by alleged container number 2 is taken on record. Stop. However, it is submitted on behalf of the alleged container number 2 that new incumbent has joined as District Institute of Schools AC Malda. Stop. Next paragraph. Leave is granted to the learned advocate representing the applicant to amend the cause title of the contempt application in course of this day and add new incumbent as additional alleged contemner. Stop. However, service of notice upon additional alleged contemner stands dispensed to it since District Inspector of Schools AC Malda is represented by learned advocate. Next paragraph. Accommodation is paid for on behalf of the applicant on the ground of the learned advocate. Hearing of this contempt application stands adjourned. List the matter under the same heading in the monthly combined list of January 2026.
Grateful, my lord.
বদমাইশগুলো ওখানে বসে আছে কিছুতেই বদমাইশ
Item number 362 and item number 361 and 362.
Lordship, I appear for the
6-1
petitioners and the added respondents. দুটো একসাথে
তো একসাথে
61
কেন
ছিল ও ঠিক আছে আমার একটাই তো অর্ডার
Yes.
Lordship, there was on the last date, there was a direction passed on 14 November 2025 to serve upon the learned council representing the state and Jila Parishad. Lordship, I have served upon them. And Lordship, in the meantime, Your Lordship, the appeal which was carried on by the state respondents and the Jila Parishad, Your Lordship, that appeal was also heard, and Your Lordship, the appeal was not allowed on 27 November 2025, Your Lordship. Lordship, the initial order of 7th March 2014. Lordship, may I indicate? 7th March 2014, Your Lordship, the order under contempt, where there was a direction that the encroachers are to be removed from the land of the petitioners. They have to be rehabilitated at the instance.
Whether the cost is paid.
Yes.
Now, they have paid the cost on, I'll give the date. Now, Lordship, they have to be removed and thereafter the land has to be handed over to me and the rehabilitation they will be doing in their own manner, Your Lordship. Till date, Your Lordship, they have not complied with the order while the contempt application was in.
Admitted fact.
Lordship, they have paid the cost on 8 December. 8.
Where is the order?
Lordship. Lordship may kindly takes. The order is starting from page 55. Order date is 7th March 2014.
Page 75.
Page 55. And Your Lordship, the relevant portion is starting from page 77. Page 77, it is the internal page 23 of the order. Lordship. May I place, Your Lordship,
Just-
page 20. Lordship. At the bottom.
Just a minute.
Lordship.
Yes.
Lordship.
So there is one part is eviction of the illegal encroachers
Lordship.
from the land of the applicant and rehabilitation of those encroachers.
Lordship.
You are not on rehabilitation. That means
Lordship, it is
that
not-
will be taken care of by the state response.
Lordship.
But it has not been, the petitioners have not been evicted. Encroachers are not
No,
evicted.
Lordship, may I? Please, please. He has not been given the right of audience before the appeal court also. I'm indicating that and I have the order on record. Lordship, now there was the direction to evict and to hand over peaceful possession of my land. I'm only concerned with that part. They have carried an appeal. Appeal was kept pending.
Who have carried in?
State respondents. State respondents have carried an appeal. The order of the appeal court is before your Lordship now.
So
Lordship,
the appeal is disposed of.
Lordship, the appeal is disposed of. Rather, I should say the appeal is dismissed. The cost remains. It was only that a caustic remark was to be kept in her service record, the record of the BLLRO. What is the background, your Lordship? For making false statements, having full knowledge that the land was.
Yes,
not-
I have seen
Lordship,
this order.
Lordship.
Now you.
I'm only aggrieved that of 2014 order, let my
Now,
land.
what you are praying for in the content?
I'm only praying that there is the order to hand over peaceful possession to me. Let it be given it to me. Lordship, and in the meantime, your Lordship, while the contempt.
Yes.
Lordship.
Yes. You have to comply with the order.
Yes. Kindly have a look. The first eviction notice was given on November 2023. Altogether 12 and 13, 25 encroachers were there. 12 encroachers have already removed, left. Before I go to that aspect, first eviction notice, thereafter land identification for the purpose of rehabilitation was done. Thereafter, second eviction notice was given because this 13 people.
25, 12 have left. 13 remains.
13 remains.
So when 13 are to be evicted?
Let me, then the third land was chosen for them.
13.
For 13. And
who are still on the land of the petitioner.
Yes. And what they do, kindly turn to the next page. I have handed up the instruction. Kindly come to that. The first one is, first page is, kindly flick through along with me. First eviction
Not
notice.
required. First is not required. I want compliance, due compliance of the
kindly come to the second page. On top, we'll find a third land was given under 6.
Second page under
6.
number 6.
Yes, third land was chosen for them. Then meeting with the occupants and their demands. All these demands have been fulfilled. Cost, payment of the construction, road, everything is done. So thereafter, out of 25, 12 have been replaced, rehabilitated on that particular land. Only 13 remains, and they are not listening. They are doing all sorts of things. They are asking DM to have a meeting, and concerned DM is sitting for them. They are not turning up.
Evict them. Evict them. Deploy police personnel, evict them.
Now, kindly come to C. Attempt to remove remaining occupants. What they are doing? At the time of such attempt, only elderly persons and children were found in the houses. They are doing it deliberately. Mr. Chatterjee is appearing perhaps on behalf of them, those 13. Kindly direct me so that I can use the force and do it.
File an affidavit disclosing all those things.
Yes.
May I only submit one thing, my lord?
Why? You are not party to it.
I'm not. I have filed
Why not
a petition regarding
after dismissal of the appeal. I will not.
No, this is not. I was not party to that appeal also. Only one thing I want to
I will
inform
not
your
take you
lordship
don't
regarding
have the right of audience.
No, only one thing I want to
Sorry,
put it on
Mr.
record
Chatterjee, you don't
for
have right
the
of audience.
rehabilitation.
You don't have right of
We
audience.
have filed a writ petition. Which
Whatever it may be. You don't have right of audience. You are not party to this contempt
proceeding. I am not a party to
please,
this.
please don't disturb this court. Please don't disturb this court. You don't have any right of audience. Enough is enough. You don't have any right of audience. Sorry, it's a contempt proceeding.
I understand.
Yes, you file an affidavit.
Disclosing everything, I'll file.
Issue. Contempt application is heard in presence of the learned advocates representing representing applicants and alleged contemners. Stop. It is alleged on behalf of the applicants. It is alleged by the learned advocate on behalf of the. Now, it is alleged on behalf of the applicants that order dated 7th March 2014, passed by a coordinate bench on the connected writ petition, till date, has not been complied with by evicting illegal encroachers from the land of the applicants. Stop. During course of hearing, judgment and order dated 27 November 2025, passed by the Honorable Division Bench on an intra-court appeal being FMA 356 of 2018 within bracket the District Magistrate and Collector Howrah and others versus Shanti Devi Jaiswal since deceased, represented by her heirs and legal representatives Sri Pradeep Jaiswal and others, close bracket, is placed before this court and same is taken on record. Stop. It is contended on behalf of the applicants that the appeal preferred, that the aforesaid intra-court appeal preferred by the alleged contemners was dismissed, but I do not find that in
It's disposed of.
Right.
Disposed of?
Yes.
Where is the disposal recorded?
I do not have ওখানে কি dismiss লেখা আছে?
আমি বলে দিচ্ছি। In view of the FMA is partially allowed, thereby
Which paragraph?
Lordship, I'm reading from paragraph 45, 46 onwards. From para 46 onwards.
But with regard to eviction, it was not interfered with. No. Only payment of cost part was there was an extension of time, and this the payment of cost is to be recorded in the service book. That was modified.
I was thinking, it's not to oppose anything. I was since this doctrine of merger would be applicable, whether the contempt would lie before the single bench. I just when I heard the partially allowed. Yes, modification. It means modification. Khoded Distilleries and Kunaya Ahmed will come. I mean, tomorrow against I'm just low point.
Yes.
Yes.
Contempt is not maintainable before this court. Contempt is not maintainable before this court. Applying doctrine of merger. Come to page paragraph 46.
Of the order.
Yes.
After the passing of this order, Your Lordship.
Yes, contempt is not maintainable before this court. He is correct.
Lordship.
Because in such view of the matter is partially FMA number so and so is partially allowed, thereby modifying the impugned judgment dated 7th March 2014 passed in WM to the extent that the portion of the impugned judgment which is directed.
Lordship, only with the
Issue.
portion of the Lordship, in that event, Your Lordship is directing the contempt to be placed before.
I will not direct anything. You have to take steps in accordance with law.
Lordship, in that event, Your Lordship, today the contempt was filed even before Lordship, the appeal, Your Lordship, was dismissed. And thereafter the
Judgment is impugned judgment dated 7 March
it is
24.
modified, Your Lordship.
Modified.
It is
So therefore,
modified.
contempt petition is not maintainable before this court due to on the strength of doctrine of merger, principle of doctrine of
Doctrine
merger.
of merger.
He has rightly pointed out
Lordship,
distilleries
Lordship,
and Kunaya Ahmed.
that he would be definitely pointing out because he is on the part of complying. The
But
contempt was
I
kept
cannot
pending.
take up this matter in view of modification of the order passed by the Honorable Division Bench.
Lordship, in that event, Your Lordship, if I subject to correction, the doctrine of merger is very specific that when the element of the order which is passed, the element has not been
That is not
interfered
the
with.
part of the judgment of Kunaya Ahmed and Khode distilleries. When it is modified, then doctrine of merger applies.
Lordship,
You have to
I
take
bow
steps.
down to that.
Yes.
It is
Keep
modified. It is not modified with regard to
the contempt application is
Lordship, in that event, Your Lordship.
yes, it was filed on 15 June 2022 when the appeal was pending, and the appeal was disposed of on 27 November 2025.
Lordship, so thereafter, Your Lordship, it was filed when
A
this
contempt
order was
application is heard in presence of the learned advocates representing the applicants and alleged contemners. Stop. Next paragraph, in the contempt application, it is alleged that order of a coordinate bench dated 7th March 2014 passed in WPA 8477 of 2003 is violated. Stop. Next paragraph. During course of hearing, judgment of the Honorable Division Bench dated 27th November 2025 delivered on an intra-court appeal being FMA number 356 of 2018 within bracket the district magistrate and collector Howrah and others versus Shanti Devi Jaisal ওটা যেটা বলে দিয়েছিলাম so and so close bracket is placed before this court and same is taken on record. Stop. On perusal of the judgment, on perusal of paragraph 46 of the said judgment dated 27 November 2025, it appears appeal being FMA number 356 of 2018 was partially modified, was partially allowed, thereby modifying the judgment and order dated 7th March 2014 passed by the coordinate bench on the connected writ petition. Stop. Next paragraph. In view of modification of the judgment and order dated 7th March 2014 passed by the coordinate bench, contempt application is not maintainable before this court on applying doctrine of merger. Stop. Hence, contempt applications is dismissed as it is found not maintainable before this court. Stop. Next, however, this order shall not preclude the applicants to take steps in accordance with law in the event judgment and order of the Honorable Division Bench dated 27 November 2025 is not complied with. Stop. Urgent Xerox certificate copy or parties to act on the server copy of this. Deeply. Huh? 537 CPAN 537 WPCRC 5425 2015. Huh. না আমি তো এটা শুনছি 362 তো কি বলছো বুঝতে পারছি না দুটো কেন দুটো there are two contempt applications.
Lordship. One was filed initially by the writ petitioners and thereafter by the added respondents. They are both the landowners.
They are equally similarly circumstanced. So why two applications?
Lordship, it was first by the writ petitioners and thereafter the brothers and sisters by the added respondents. So thereafter they have preferred a contempt.
দেখি ওটা দেখি and in both the matters two separate appeals were preferred.
One, only in one. Lordship, in to the
I
other
tell
bit, my
I'm
contempt is
clarifying.
still alive.
I'm বলেননি writ
Lordship, yes,
writ
yes.
petitioner is also a landlord and the co-sharers been made as respondents in the writ petition.
Yes,
Co-sharers of the land been made as respondents in the writ petition. So writ petitioner has come up with one contempt application.
Co-sharers who are respondents in the writ petition.
In the writ petition, they have also come up with the another contempt petition. তাই তো?
I'll
That is CPAN. দেখি বাদ দাও See only. কোথায় CPAN টা কোথায়?
Second CPAN আমার কাছে নেই।
CPAN 2812 is the second contempt application.
Second CPAN I am not having.
আচ্ছা ও তারপরে ওই হেডিং করবে CPAN 2812 of 2014.
Lordship, may I be permitted to
CPAN, just a minute. CPAN 2812 of 2014.
এটা আছে।
তারপরে এই এটা শান্তি দেবী জয়সওয়াল সিন্স আদার্স ভার্সেস সো এন্ড সো এটা করে দেবে তার সঙ্গে WPCSC CPAN প্লাস WPCSC টাও দিয়ে দেবে আচ্ছা ইন ভিউ অফ দ্য অর্ডার পাস্ট in WPCRC 425 of 2015, that is the first contempt. Hey, Shivu, 425 of 2015 WPCRC is the first contempt.
is the first.
In view of the order passed in WPCRC 425 of 2015, WPCRC, so where is the number? Second number WPCRC
537/2020.
করতে পারবো না কোথায় কিন্তু WPCRC দাওনি তো এখানে
আমি কারেক্ট করে দিলাম এখানে কি না করলে ভুল হয়ে গেলে
এটা হচ্ছে সেকেন্ড কন্টেম্পটা ফার্স্ট কন্টেম্পটা হয়ে গেল সেকেন্ড কন্টেম্পটা WPCRC দাঁড়াও সেকেন্ড কন্টেম্পটা WPCRC কোথায়
কোটি কন্টেম্প চলে গেল
হ্যাঁ এই যে বললে সেকেন্ডটাই রুল হয়ে গেছে পড়ো তাহলে আরেকবার যেটা অর্ডারটা করছিলাম এইটা in view of the order passed in WPCRC 425 of 2015, CPAN 537 of 2022 is also dismissed with a leave to take steps in accordance with law in the event, judgment and order of the Honorable Division Bench. Dated 27 November 2025 is not complied with.
In that event, if your lordship, I am permitted to indicate now since 27th November, this order is only with regard to payment of the cost. Then the
No, there's a modification of the order passed by the coordinate bench.
lordship.
So the order passed by the coordinate bench merges with the order passed by the Honorable Division Bench. Therefore, you have to take steps accordingly.
Lordship. Now the contempt application will now go before
I am not
the
exercising any advisory jurisdiction, Ms. Ghosh.
grateful my lord.
Doctrine of merger, what is doctrine of merger?
Lordship,
If there is a
earlier
modification,
order-
if it is a dismissal simpliciter,
lordship, then the entire
then
order-
doctrine of merger does not apply. But if it is not a dismissal simpliciter with a modification, appeal is partly allowed. So
That
therefore,
means
the original order passed by the
is
coordinate
alive.
bench does not remain.
No, it is alive. And
It
is to be merged
merges with the order
the
of
order subsequent
merges with the order passed by the honorable division.
Grateful, my lord.
Deeply. At the time of filing the contempt application, this order was not there. That's why contempt application was filed in 2022 against the considering violation of the order violation of the order dated 2014. Now the situation is altered in view of the judgment delivered by the honorable division bench in the month of November 2025. Rightly pointed out, Mr. Dho.
Grateful.
No, I have to face contempt.
Item number 363.
I am an alleged contempt. It is over. 65.
কত কল হলো কত কল হয়েছে 363
Page 29, Lordships. Pass the region order, Lordship, on the last occasion. He had been directed to pass the region.
Time to file affidavit of compliance. Order is complied with.
No, it has not been complied. It has been rejected. It has been rejected.
Rejected. There is a direction to consider.
To consider.
So then order is complied with. Rejection order cannot be gone into in a contempt. Mr.
This is
Mishra.
the first case that should have been considered by the district inspector of school.
Where is the order? Where is the order?
On page 5. Page 5 of no.
We had obtained the physical education in mastered 2003. Special bench judgment, division bench judgment already has supported it. On that ground, 2003.
Order is dated 3rd June 2014.
My lord.
Whether the opportunity was given to the petitioner.
Opportunity was given to the petitioner.
So then where is the content? If it is rejected, then you have to challenge it. If it is rejected, you have to challenge it. Where is the rejection order?
That is page 5 of the compliance report.
You have not granted benefit.
No, my lord.
Direction to grant benefit in accordance with law. If it is found that the benefit cannot be granted or benefit ought not to be granted in accordance with law, after granting opportunity of hearing to the applicant, an order is to be passed. That order is passed. So where is content?
In accordance with law, I am
No, you are submitting at the first instance, you have submitted that no, order is not complied with. That's why I'm asking you.
No.
Where is the violation?
There is no violation. Ample opportunity has been given.
Yes, sir.
Thereafter, pass the region order. Violation, Lordships, the 2014 in belated stage already compliance had been given. Ample opportunity had been given.
Affidavit of compliance affirmed on 5th December 2025 by the Additional District Inspector of Schools AC South 24 Parganas is filed and taken on record and is taken on record. Stop. Order of the District Inspector of Schools AC South 24 Parganas issued with a memo dated 7th April 2025 is enclosed to this affidavit of compliance, whereby whereby claim of the petitioner to grant benefit was higher scale of pay.
Higher scale of pay.
To grant benefit of higher scale of pay was rejected. Stop. Since decision has been taken by the alleged contemners It appears that order of the coordinate bench dated 3rd June 2014 is complied with. Hence, contempt application stands disposed of and contempt proceeding stands dropped. Next part. However, this order shall not preclude the alleged contemptor to take steps against the order dated against the memo dated 7th April 2025 in accordance with law.
But I am supplying a copy of the compress.
Urgent Xerox certificate copy.
That's better, my lord, complied with my lord.
Yes, call the list.
Item number 364.
Three, six. Order is complied with.
Yes, my lord, already, my lord. I also, my lord, communicate Mr. Tarikanath Mukherjee, who is the advocate record.
At the time of rise, just before recess, he mentioned, so the order is complied with, matter can be disposed of. Then this court didn't have the time to pass order. I remember.
Kindly dispose of this matter. Already he received this money, all these arrears.
এই শুনুন, এই দরজাটা খুলে দাও, সেকেন্ড হাফে গরম করে দিবি। Order is dated 4th December 2015.
Yes, yes, man.
So this higher scale, postgraduate scale of pay along with arrears paid.
Yes.
Any document in support of such payment?
Yes, my lord. Yes, yes, my lord. Previous occasion, my lord, I had submitted before your lordships, my lord. This has, my lord.
You filed a document?
Yes, my lord.
By way of affidavit of compliance?
No, my lord, previous occasion, my lord, I filed affidavit in compliance with the part of this compliance because, my lord, all letters, my lord. And, my lord, money has been, this document shows, my lord, this 23 lakhs 64,098.
$23,64,898.
My lord.
Is the total amount paid
My lord,
towards area or towards area and current benefits?
area and connected benefit, all are.
Have you served notice upon the learned advocate?
My lord,
Last occasion I directed.
my lord, not, but my lord, verbally communication, and my lord, he
Issue.
tell me, my lord, he received this, his client received this money.
At the time of call, no one represents no one represents applicant. Stop. Alleged contemners are represented by learned advocate who has submitted order passed by a coordinate bench on 14 December 2025 on the connected writ petition is complied with. Stop. In support of such submission made on behalf of the alleged contemners, memo dated 30th October 2025, copy of the memo dated 30th October 2025, issued by the District Inspector of Schools AC Kolkata is placed before this court and same is taken on record. Next paragraph. Placing reliance on said memo dated 30th October 2025, it is submitted that benefit of higher scale of benefit of postgraduate scale of pay was extended to the petitioner and area dues were also paid by releasing rupees 23,64,898 in favor of the petitioner. Stop. Next paragraph. In view of aforesaid submission made on behalf of the alleged contemners, contempt application stands disposed of and contempt proceeding stands dropped. Urgent Xerox certificate copy.
Item number 365.
365, I for the petition.
365.
Lordship, I am the present encumbrances. Compliance has been done. Lordship is
The file.
Complied with?
No.
10th of April 2020.
All occasion, contemner, say submit, they have complied with. What happened, initially, the order dated, 10th April 2017 is the order passed by this honorable court, which is violated by my learned client. What was the direction? Kindly have a look the direction passed by this honorable court, appearing order starts from page 29 and direction is page 30.
Dusting. Order date 10th April 2017.
Yes.
Dusting. Yes. Uh, uh, how the order is violated?
There was twofold direction. My lord have already seen, my lord, the page 3, considering the submission as advanced by the learned advocates for the respective parties, and after perusing the records, I direct the respondent number 5, the Pradhan Simuli Gram Panchayat, North 24 Pargana, to take a decision in accordance with law within a period of such and such.
Lordship, we have taken a decision. So, Lordship, is a compliance report is
My
page
lordship,
6.
get the chance, Mala, you will submit. Mala, after Mala communication, the notice was issued, inspection was made. After inspection, the inquiry report submitted, and from that inquiry report, it will reflect it. Mala, the inquiry report, Mala, at dated.
No, I am asking you whether any decision is taken by the respondent number 5.
Yes. The respondent number 5 taken decision, and Malad asked the private respondent to demolish the unauthorized part. Thereafter, Malad, no demolition was carried out. Then Malad,
Just a minute.
Second direction is page 4, Malad.
Just a minute. So your submission is that decision was taken by respondent number 5.
Yes.
And it was found that, or it was found with a said decision that there was deviation while constructing the building in question, and which requires demolition in terms of this order. Come to page 4.
Yes, my lord.
Please read the same paragraph.
If needless to mention, if it is found that the private respondent have already taken steps for construction of one extra floor on the same building beyond the sanction plan, and if it is found that the cantilever has been constructed beyond the sanction plan, well, here I am pausing for a moment. The cantilever has been, if cantilever has been extended beyond the sanction plan, and the concerned Pradhan is at liberty.
At liberty. And no time is fixed. How contempt is maintainable?
Thereafter, kindly have a look. The act.
Yes, where is the order?
Lordship, page
then
compliance report.
Please, where is the order? Show me the order of the section of the respondent number 5.
Well, he has
Lordship, the page 6 of my compliance
report.
Page 6, or Lordship.
Where compliance report?
Which have 10th 9 2025. Lordship is the evidence in compliance.
Before that, my lord, kindly have a look, my lord, the compliance report filed by the contender number 1, my lord, dated, my lord, dated 25th February 2025.
This was the recent decision, Lordship.
This
page
is
6.
your affidavit of compliance. Affidavit in exception is there.
Lordship,
compliance report.
compliance
But two compliance report. One is filed by the contender number 1. That is contender number who was the.
Where is the final decision with reasons dated 22nd July 2025?
Lordship.
Why there was so much delay?
Lordship,
please wait. What is going on? Take your seat. Order was passed on 10th April 2017. And why the decision was taken on 22nd July 2025 when the contempt proceeding was being considered by the coordinate bench?
Lordship, the erstwhile Panchayat Pradhan was there, my lord. Subsequently, we are encumbrance, my lord. We have taken decisions on respect of this. My lord, the fair opportunity of the hearing. Subsequently, my lord, we have passed this order.
Where in the order it is pointed out that there are certain deviations?
Well, kindly have to pay compliance report filed by the contender number 1 dated 25th February 2025.
No, it's 22nd July 2025.
No, before that, they have already filed a compliance report.
But this is the final decision.
No,
that is report, but this is the decision.
No, there was also
This is the final decision.
There was also a decision. They have
encumbrance-
already order was twofold order. They initially they will take decision and then they ask the incumbent respondent number.
There is a subsequently revised
Where-
sanction plan
where-
that
where
has
is the
been,
scope
that
in
has
the
been
order?
shown, my lord, after.
What is the scope?
There is another compliance report.
Yes, 25th February 25. Filed by the contender number 1.
That was the erstwhile Panchayat Pradhan.
10 September 2025. This is the
Lordship.
last compliance report.
Lordship.
Filed by Santosh Kumar Boidya, contender number 1, dated 25th February 2025. The page annexure P1 the notice.
25th February 2025.
Yes, sir.
Yes.
The page 4 is the notice of hearing. 8th June 2017. Thereafter, the inquiry report. February 2018 inquiry report.
So where is the finding or
there are
where is the report to the extent that there was deviations or
the
illegal construction?
The premises for permission for construction up to 2-floor approved area, ground floor 346 square feet and first floor 464 square feet. But in inquiry report says,
there was a
so what? What is the finding?
Thereafter, the notice, they ought to have taken the next page, the page 8th February 2028 issue. That apart, my lord, one submission,
Contempt application is heard in presence of the learned advocates representing the applicant.
In 1.14 decimal land, how my learned friend client constructed more than his
Presenting the
area,
applicant
592
and
square.
alleged contempt. Stop. Next. Mr. Bhagwat Chaudhary, learned advocate representing the applicants, submits that order dated 10th April 2017 passed by a coordinate bench on the connected petition is violated by not demolishing portion of the building in question, which was constructed beyond the sanction plan. Beyond the sanction plan, stop. It is submitted that steps were taken by the concerned Panchayat authority to find out nature of alleged construction in terms of the order dated 10th April 2017 and inquiry report and inquiry report was submitted dated 3rd February 2018, wherein it is indicated while making construction, deviations were made. And construction was not in consonance with sanction plan. Based on this inquiry report dated 3rd February 2018, it is submitted that in spite of pointing out unauthorized construction in the building in question, those constructions were not demolished in terms of the order dated
8th
10th
February.
April 2017. Stop.
8th February, one notice was issued, my lord, to asking them to demolish, my lord.
However, such submission is disputed by the learned advocate representing alleged contaminers based on decision taken by the Pradhan Shimulpur Gram Panchayat dated 11 July 2025, which is annexed to the compliance report affirmed on 10th September 2025. It is submitted no further steps are required to be taken in terms of the decision, said decision dated 22nd July 2025, taking note of the directions as contained in the order dated 10th April 2017. Next paragraph. On perusal of decision dated 22nd July 2024, it transfers concerned Pradhan made a finding that no legal or procedural ground exists to cancel, modify or interfere with the sanctioned plan. Stop. Since nothing is pointed out in the decision dated 22nd July 2025 relating to unauthorized construction in the building in question,
Lordship, there is a revised sanction plan is there.
demolition of unauthorized construction, which according to the applicant is required to be carried out. Ought not to be directed while deciding this contempt application. Stop. Stop. An order was, a decision was taken in terms of the order dated 10th April 2017. And if the applicant is aggrieved by such decision, necessary steps are required to be taken in accordance with law. But validity of such decision need not be examined in contempt proceeding. Stop. Next paragraph. Moreover, video order dated 10th April 2017 concerned Pradhan was granted liberty to take steps in accordance with law in the event construction is made beyond the sanction plan. And while directing the concerned Pradhan, no time was fixed. After decision is taken by the Pradhan in terms of the order dated 10th April 2017. Stop. Next paragraph. Hence, court finds, in view of decision taken on 22nd July 2025 by the concerned Pradhan, order dated 10th April 2017 is complied with. Stop. Contempt application stands disposed of and contempt proceeding stands dropped. Next, however, this order shall not preclude the applicant the applicants to take steps in accordance with law if grievance of the petitioner is not redressed. Urgent xerox copy.
Great.
Next.
Item number 366.
I'm appearing for the petitioner. In this matter, two incumbent has been inducted, my lord. So I have to correct the cost settlement.
Yes.
New incumbent has been inducted, my lord. The special land acquisition officer, my lord. The new incumbent name is Reena Ghosh. Already twice I have added the new incumbent.
But this was amendment was already made on 18 September.
Yes, again, new incumbent has been inducted, my lord.
Special land acquisition collector has been changed.
Now,
who is appearing for the contemners? Shishchandra Bandyopadhyay, Devopriya Karan. Where are they?
I have no idea, my lord. The last time they appeared and they
very issue. At the time of call, learned advocate representing the applicants prays for leave to amend the prays for leave to amend prays for leave to amend post title of the contempt application, thereby add present incumbent as additional alleged contempt. Stop. Leave is granted to amend the cost title in course of this day. Stop. After such amendment is carried out, learned advocate for the applicants is directed to serve notice enclosing contempt application and copy of the order passed today upon the additional alleged contemptor by 24th December 2025. Stop. Next paragraph lists the matter under the same heading in the monthly combined list of January 2026. Stop. Add another line. Next paragraph, learned advocate representing the applicants is also directed to serve notice upon the learned advocate who represented the alleged contemners on the last occasion. Or who represented the alleged contemners on 4th March 2025.
Item number 367.
Yes, my lord. In this matter, pursuant to the order of 3rd February 2023.
Lordship, this is the affidavit.
Just a minute. Yeah?
Lordship, in compliance with the order date 3rd February 2023, this is the affidavit.
Order is complied with.
Exchange, not compliant.
Okay, not compliant.
My lord, in this matter, I am appearing on behalf of the private respondents, my lord. My lord, against the demolition order, my lord, appeal has been preferred before the competent civil court, and all the proceeding has been stayed. My lord, I shall produce the
order of the High Court has been stayed by
no,
the
my lord, order.
appellate
No,
authority.
order of the
In the appeal court.
my lord, order of the municipal authority. That order has been stayed by the civil court. My lord, I shall produce the certificate.
Yes, you have preferred an appeal. Civil court has passed an order of stay. But how that will affect the order of the High Court? Where is the order?
But I did not serve any copy, my lord, in colleagueship with the.
No, but he is informing the court the relevant facts.
Yes, my lord, problem is that, my lord,
yes, let me see the order first. If it is based on the order which is under challenge before the appellate authority, then court has to think over it.
Page number 30 in the contempt application. Page number, my lord, not 30. 20.
27 is the appeal. Page number 19, my lord. 19. My lord, first of all, my lord,
Order is dated 18 September 2020, or 18 September 2017.
no, my lord, 30th August, page number 19 of this application, content application. Relevant portion, my lord, order in portion, my lord, page number 19. Due to illegal construction by restraining my ingress.
Just let me go through the order. Order dated 30th August 2017.
Yes, my lord. Thereafter, prefer an appeal also.
Yes.
Thereafter, my
What
lord,
is the, where is the violation?
violation, my lord, in the page number, my lord, page number 4, in the order, page number 22, my lord, in the page number 4, page number 2.
22 of the contempt.
Contempt, order, contempt.
Contempt application. Page 22. Yes,
22.
yes, yes.
See, my lord, first of all, my lord, 2013, my lord, I filed a writ petition for demolition. In the writ petition, my lord, Honorable Justice Joint Bishop's filed, my lord, order, my lord, page number 64 in the
That is not required.
Yes, my lord.
Contempt. I am
Thereafter,
to
my lord,
consider whether the order dated 30th August
in the
2017 is violated or not. You demonstrate that where is the violation.
In the reason order, my lord, the municipality, my lord, decided it is illegal, unauthorized. Decided, my lord, page number 72. Thereafter,
In terms of the order passed in the
Honorable
first
Justice
round
Joint
of litigation.
First round of litigation.
Yes.
Thereafter, my lord, I filed a contempt application, but Honorable Justice Tandon, my lord, said that this is a consider order, my lord, it is not maintainable, it is a contempt application. Thereafter, again, my lord, filed a writ petition. In respect of the writ petition, my lord, Honorable Justice Tandon will file an order. In this, my lord, and challenging this order, my lord, he filed an appeal. Appeal was also dismissed. My lord, page number 22, since the said respondent has filed their application for recalling the order of demolition, the competent authority is directed to dispose of the said application within 2 weeks from the date of communication of this order. So did not, my lord, do this.
So it was not recalled.
Not recalled, my lord, at the point of time, according to, as per order of the Honorable High Court, my lord. Now, my lord, after filing the contempt application, my lord, earlier occasion, my lord, the Honorable, the learned friend, my lord, said, in 2023.
What is the fate of the recalling application? Which
Recalling
was pending before the municipality?
municipality, but within 2 weeks, my lord, mandatory, my lord, directed, but not, my lord, disposed of.
It was not disposed of.
Not disposed.
Whether subsequently it was disposed of.
Subsequently, I came to know that dispose of, challenging this order, he filed an other application before the civil court, where the municipality did not appear, my lord, file an order stay, order granted by the.
And how this order will be implemented?
But
if there is a stay on the order of demolition, now it appears from your submission that there is an order of demolition. Now, against which the private party preferred an recalling application. Recalling application was dismissed. The order was not recalled. Yes. Against which an appeal was preferred before the district judge in terms of section 220 of the West Bengal Municipal Act 1993.
Subsection 3 of
recalling
218.
application not
Subsection 3 of 218.
218 3 of the West Bengal Municipal Act 1993. He is submitting that in that appeal there is an order of stay. Staying demolition order.
When it, as per direction, when disposal of, when recalling application heard, my lord, kindly look after. As per order. As
But
per order.
You come to the relevant part of the order, come to page 21.
Yes,
of the page 21, relevant part of the order passed by the coordinate bench on 30th August 2017.
But page number 20.
Please come. Last paragraph, it is observed in the last paragraph. So long the order of demolition stands and stares at the face of the said respondent.
Yes, if
the order of demolition is stayed,
yes,
then subsequent order goes.
Kindly see page number 22. Kindly see page number 22. In the event that said application decided within the time indicated herein above.
But prior to that, there is a condition. So long the order of demolition stands. If order of demolition is stayed by the appellate authority, what is the scope of giving effect to your demolition?
The recalling application, if dispose of within the mandatory period indicated by the court. In the event
now there is further check valve. Come to page 22.
Yes, my lord.
Then after the running paragraph, first, second, third paragraph. Read third paragraph.
The said authorities shall not be swayed by the.
In the event the application, event the said application is decided
within the time
within the time indicated herein above, that is 2 weeks.
Yes.
And the municipal authority found that there is no impediment in proceeding to implement the order of demolition.
Yes. Yes. He shall do so, shall see that the entire, but
there are two check valves.
Two check valves. One is the mandatory.
One is so long the order of demolition stands and stares at the face of the said respondent. As on date, this demolition order does not stand. it is stayed by the appellate authority. Now the second check valve, in the event the said application is decided within the time indicated herein above.
Yes.
And the municipal authority found that there is no impediment in proceeding to implement the order of demolition, it shall do so and shall see that the entire exercise is completed. Now there is an impediment.
So it is prerogative of the municipality, but kindly see,
Yes, where is the order of stay?
23,
Where is the order of stay by the appellate authority?
My lordship,
2023.
in my compliance report,
yes,
lordship, page
2023.
31. At that time, that is was the stay. At
Is
the
it
time
totally
when
in your compliance report,
lordship, page 31. A reason not to pass the lordship.
alleged content number 1 affidavit,
Lordship.
page 31.
And lordship, yes. And it's a purpose. Stay there.
This interim order of stay was passed on 6th February 2023 till 20th April 2023.
Thereafter, what saying that is continuing.
Where are the subsequent
It is
orders?
not
Total subsequent orders.
My lord, I shall file. My lord, kindly give me
You
one.
produce subsequent orders.
My lord, the recorded lawyer has not come. My lord, kindly give me 1 week time. My lord.
Yes.
All along,
My lord, I shall
Larnet advocate
submit.
all along appeared in the
But I have no
petition
brief, my lord. I have no
and
brief in my
second
hand.
thing, kindly see the as per order,
My lord, I shall
challenging
file.
the recalling
Yes.
order.
My lord, kindly give me 1 week time.
Yes, that you will get.
Challenging the order passed to recall, but it is a challenging the order passed in the 2013, my lord.
By filing this contempt application, prayer is made to implement the order, to implement the directions or to comply the directions as contained in the order dated 30 August 2017, passed by a coordinate bench on connected writ petition. Stop. In other words, prayer is made to demolish unauthorized construction in terms of demolition order dated 31st October 2013. Stop. Next paragraph. During course of hearing, it is pointed out on behalf, or it is pointed out by the learned advocate representing the alleged contemners that an appeal was preferred. You are party to this writ petition?
My lord?
Yes, well.
Respondent number 5. মিনতি নস্কর। আচ্ছা, কি বলছিলাম? By respondent number 5 in the writ petition before the civil court in terms of section 218 within bracket 3 of the West Bengal Municipal Act 1993 and interim and an ad interim order was passed on 6th February 2013 by the civil court, thereby staying the demolition order dated 31st October 2013 till 20 April 2013. Stop. It is submitted on behalf of the respondent. It is submitted on behalf of respondent number 5. That subsequent, it is submitted on behalf of the respondent number 5 and municipality.
Lots of, at that relevant time when I was
that
went to demolish that
ad interim order passed on 6th February 2023 was subsequently extended.
So that is not within the
within your
knowledge and no copy has been
কি বললাম, it is submitted on behalf of. Are you aware of that the ad interim order?
No communication has been made to the municipality.
Municipality is a party.
My lord, my junior has not come today. That is my problem.
Municipality is a party.
He requested me to take time. My lord, kindly. Yes.
Did not appear on one day in the lower court.
Another advocate has
The municipality.
না তার আগে সেন্টেন্সটা বলো।
Municipality did not take steps for vacating the order.
Stop. Till 20th April 2023. Stop. বাকিটা কেটে দাও। However, today it is not apprised whether subsequently ad interim order dated 6th February 2023 was extended or not by passing orders by the civil court. Stop. On behalf of alleged contemners and respondent number 5 in the writ petition, accommodation is prayed for to obtain instructions whether addendum order passed on 6th February 2023 still subsists or not. Next paragraph. Hearing of this contempt application stands urgent in order to enable the learned advocates representing the alleged contemners and respondent number 5 in the writ petition to obtain instructions. List the matter under the same heading for further consideration in the monthly combined list of January 2026.
Other points kept open, my lord.
I have decided nothing. First, I want to see in contempt what other points.
In one matter, Justice Mantha, my lord, there is a in this type of case, it is a under the jurisdiction of the lower court. Lower court or not, that is the question.
Huh? That is the order of demolition.
Because this
Lordship,
type of issue,
affidavit filed by the alleged contender.
type of issue is under the jurisdiction of the lower court or not. That's why, my lord, I am to your lordship submitting.
Why not? There is a statutory provision to pay for appeal.
No, my lord, there is a one
And the coordinate bench, while passing order, has taken note of it.
Yes, my lord. That's why, my lord,
Yes.
Lordship,
satisfy with your
affidavit filed by the alleged contender we kept with the record.
Yes.
I have filed that affidavit.
reply also filed. Opposition and reply both filed. Kept with the record.
देखिए
Only record.
if the order or demolition order remains, you have case. If demolition order does not survive or temporarily stayed, at present contempt application cannot be proceeded with.
My question, my
Your
your
very prayer of demolition rests on the order of demolition order passed in 2013.
Yes, my lord.
Now, if against that ex parte order an appeal is preferred and the stay order is
Not
passed,
expert order, my lord.
and stay order is passed, today this order cannot be implemented unless and until this appeal is decided finally.
But the problem is that is tomorrow the interim order gone. My lord, your lordship subsequently, my lord, contempt application disposed of. My lord, thereafter what will be happening, my lord? Again, my lord, required to file a writ petition.
There is a direction to file affidavit of compliance.
Yeah, 3rd February 2023. Complaint, my lord, affidavit opposition and reply.
Affidavit in opposition to this contempt application and affidavit in reply are filed today on behalf of alleged contemner number 1.
Yes, sir.
On behalf of alleged contemner number 1
Chairman.
and applicants in terms of the order dated 3rd February 2023 passed by the coordinate bench and same are taken on record.
My lord, kindly direct me to give me a copy, my lord.
I cannot. দেখো 3 মিনিট আছে আর কিছু করার নেই। কন্টেম্প শেষ হয়ে গেল তাই তো?